Welcome, everybody, to another episode of the Single Mothers Foundation podcast. My name is Zanele, your host, and today I am joined by Philasande Memela, who is going to tell us everything about the law, what the law says about our children, about our co-parenting, about the father, about the mother. And we are looking forward to it. She's a great friend, guys, and she's journeyed with us in this foundation as well. So, yeah, welcome, Pila. Welcome, my friend.
Thank you so much.
So
Thank
I'm
you
going
so
to ask her
much.
to introduce herself, who she is, how did she end up on law? Like, take us through that journey.
Oh, wow. I'll try to summarize
Let's
it. So I'm Philasande Memela from MKS Inc. It's a firm based in Rosebank, Johannesburg. I am the director of the firm and I specialize in family law and commercial, but we do offer other services as well, inclusive of conveyancing, for an example. But it's just that my area of specialty would be on this too.
Okay.
How did I journey into law? Funny story is that law was my second option.
Okay.
It was my second option. My first option was dentistry.
Oh,
I
really?
really wanted to be a dentist.
You do have beautiful teeth.
Thank you. I really wanted to be a dentist, but my parents unfortunately crushed the idea. And the more I thought of it, the more I was just like, okay, because you know how dentistry can be. So my dad usually asked me this question. Okay, so what if you are placed in a very rural setting, for an example, and you're told to clean the person's teeth? Oral hygiene would not be as so he said, you're very particular. Are you sure that you'll be able to
to do that.
stomach
Yes,
that? And
yeah.
so I was like, the more I thought of it, and my mom, she was just putting pressure on the side to say, no, maybe you should reconsider. So I was like, okay, well, that said, best option would be my law. Let me go for my second option. And that's how I ended up being in law. Otherwise, I would have been a dentist.
Wow, completely different.
Very different, very different. But yeah, and I'm here.
Sure.
I'm here and I'm enjoying it. I actually think that God aligned me to be where I'm at, because I don't think maybe I would have contributed the way I want to contribute to society had I been a dentist. I don't think so. It's a fulfilling job, what I do, and it's really driven by passion as well. So I thank God that I journeyed and I ended up,
Where you are.
where I am. I did.
Yeah. So, Pilar, I'm just going to jump straight into it.
Okay.
You know the story of the Single Mothers Foundation. I'm not going to get into it.
Yeah.
I think society was never ready for us.
Indeed.
We grew up where you have a child back in the days, and then like they're raised by your parents,
Yeah.
and it's hush hush. They like your siblings, and
Yeah.
it just life happens. If you find out that this was actually not my siblings, this is actually so and so's child, my sister's child, or whoever's child, but life has happened. The child never needs to go to the dead side of the family. Like the child is for this family.
Yeah.
But things are changing.
Yeah.
I think we are quite a woke generation. We know
True.
our rights.
True.
And I think also as mothers, we understand the importance of the father's involvement, because we unfortunately don't have mothers where we can say, okay, you can raise them, I'm coming back. We are hands-on with our kids.
Yeah.
And but now you get a mom who's raising their children and the dad is not part of the picture. How do you handle that? And I'm the mom and I'm like, I want this guy to be part of the child's life. I want this guy to start paying school fees. I've gone the maintenance route and it's tedious. And I think that's where a lot of people end up, because I think the law is on the mother's side and mostly on the child's side as well. How do you handle that? Take us through the journey, number one, what the law says about the co-parenting situation. Yeah.
Okay. So Very important. I just want to first perhaps jump into what you said in your introduction to the question when you were saying that we come from a generation where if a child is born out of wedlock, then the child belongs to the mother's family.
Family, yes.
Right. I want to start there and say, well, indeed, you're correct in that generations are changing, and obviously we are moving with the world and moving with what society now wants, and it is no longer like that, especially when it comes to the law itself. A child born out of wedlock must experience both the maternal and the paternal side of the families, and it is very important to balance the two. That is what is required. Like, that's what the law says. It's no longer a maternal child situation only, but the child belongs to both families. Now, jumping straight to the question that you asked pertaining to parenting, planning, maintenance, and all of that, if a father is not involved. First of all, it's important to journey through parenting, co-parenting, let me rather put it that way. It's important to journey through a co-parenting using the mechanism in law called, parenting plan. So the minute you and dad are no longer, for an example, together, and you decide to part, ways, and there's a child or their children involved, it's best to take the approach of going straight to an attorney. An attorney that specializes in family law would be more advisable, so that you can then sit down with your attorney, go through what you are experiencing, go through the needs of the child, go through what can be done before it gets too toxic and you wait for too long, right? Immediately when you guys are saying we're separating, we're parting ways, it's advisable to just go straight for it, so that whilst emotions are still, not too high, because it's very frustrating to go for someone, let's say just 12 months later, then you realize, oh, shucks, is actually not maintaining the child. What can I do? It's more frustrating than when we're still together, we're parting ways now, we're agreeing that we're parting ways. What can we do, right? So if the environment, of course, allows, because there's some environments that don't allow for the conversations to even happen, wherein you won't be able to even see an attorney, but preferably go see an attorney. And the purpose of seeing an attorney, it is to draft what we call parenting plan, right? A parenting plan is a very good tool to manage both families and both mom and dad's obligations and responsibilities, and it channels how the child should not suffer from you and dad basically separating. So it will cover a lot of aspects, right? It will cover and it will emphasize firstly on the issue of the 50-50 contribution that you guys would have to deal with, contribution financially. And it will cover the fact that just because mom, for an example, might take the child, stay with the child, and be the caregiver of the child, it doesn't necessarily mean that just because of the caregiver, you're not supposed to consult with dad. Dad still has the same rights as you have. So when we say 50-50, we don't only mean 50-50 financially, we mean 50-50 in every aspect. We mean that mom, dad must literally co-parent this child. Whatever that the child is experiencing, dad must know. Just because dad is not there 24/7 with the child doesn't necessarily mean that he must not know, and he must not be involved, and he must not be alerted to, for an example, the child is ill. You have to. It's a responsibility of the child, of the mom who is with the child at the time to actually alert dad. But also, we're seeing an interesting development in law, which now some people have an issue with. And I think it's actually very fair. I love it. The fact that tables can be turned. Dads can now stay with the children. And mom can be the parent not having 24/7 access to the child, but rather dad can now have 24/7 access to the child. It just depends on what parents agree to. That's if indeed it is a parenting plan, who's the parent best fit to
to
raise
or
or to
live
24/7 live with the child.
Yeah.
It just depends. And it's nice when parties are agreeing, especially like entering into a parenting plan, and we don't have to go through an inquiry. There's a process that we go through. So a parenting plan can either be by mutual agreements between the parties. That's like us sitting down, going through, dissecting what are the needs, like I said in the beginning, and what is mom offering, what is dad offering, how are we going to look around holidays, how are we going to look around go through visitations, hourly visitations, for an example, during the day, how are we going to do telephonic correspondences with the child, with the parent that is not going to be 24/7 available for the child. So just because I'm not physically there doesn't mean that I can't access the child every day. So that's what the parenting plan entails. It entails like detailed planning. Like we go to the T when we plan that, when we draft the parenting plan, to the point that we will say, okay, if the bedtime will be 7, for an example, 7 p.m., dad can have call time with the child, video call the child, let's say from 5 to 7, right, before bedtime. And vice versa, if dad is the one staying with the child, mom can video call between this hour and this hour. And this is just to keep routine.
Yeah.
So mom doesn't have to only get access to the child, let's say, on the weekend,
Yes.
or we have to alternate weekends. The best I always laugh at this. Clients always know about this alternative weekend thing, because I guess like society has spoken about it so much that people know about the alternative. But it's not really alternative. It just depends on what the parties want. I have, for an example, clients who will say, well, I want my children every weekend. And it's fine. And you have, one would say funny arrangements where parents will say, for an example, okay, you take a 7-day routine, I take the 7 days. So it's literally interchanging.
Yeah.
And we just share the helper. So the helper will go with the children when it's mom's
Wherever
weekend.
they are,
And we're just alternating. So that's the flexibility that the law has allowed through the parenting plan. Then you have a scenario where, for an example, a parenting plan will be entered into now in not so like favorable, good condition type of setting, wherein mom and dad are like, it's just a toxic ending. Unfortunately, they can't speak. Like there's no speaking. With the ending of the relationship did not allow for the opportunity for us to go through, like a mutual separation. What are we looking at when it comes to the children? And in that setting, parenting plan is still the option. It's not like to take away the option, but now it changes the dynamics a bit, in that if mom comes to me as a client and says, okay, look, I have this scenario, I separated with the father, we're not talking, but I want him to be part of the child's life, right? How do I get around it? I say, okay, fine, we will draft a parenting plan, or we will go through, if he doesn't want to cooperate, we will go through the family advocate's office and do an inquiry. Either way, you still have to go through the family advocate's office, but when you have already, as an attorney, having drafted the parenting plan, parties are agreeing to this plan, they've signed it. It's just what we term as an endorsement that the family advocate will then do. It's to go through the parenting plan, okay, confirm that indeed, as an attorney, I didn't only favor the mom. It's literally aligned with the law. It protects the child as best as it could, and they will endorse it, right? And it becomes, like a stated agreement. It's a binding agreement. It's endorsed. We can go through court to make it a court order, right? So that's valid. Then in a scenario where now my client is no longer, like in a good communication with the father of the child, then I can't do a parenting plan now, because remember, if I'm drafting the parenting plan, I'll be basing it on what my client wants, the mom, right? And it cannot be, because we're looking at the child's needs. The child's needs are the most paramount that we have to consider when we draft a parenting plan. It's not about mom, or it's not about dad. In other words, it's not about my client. So what happens there, I have to go to the family advocate and state the facts of what's going on, and require then an inquiry to be held. What this means is the family advocate's office will then arrange for a date where parents must come in, right? And the children will be there as well, but the children are in a separate room, safe room, nice room with kid is playing toys, reading time. There's nothing that changes their environment. They're not part of the conversation that the family advocate will then have with the parents. So in that family advocate's inquiry, then the family advocate will inquire from both parties as to what must take place, where are the indifferences, what is the best way to go around parenting the children now that both parties are no longer together. And from there, then she makes, or their office makes a recommendation, what we know as recommendation. Then the recommendations would be binding just the same way that the parenting plan would have been binding. Then those recommendations are made basically a court order, and then we function, or the parents then parent and function through those recommendations that were made. It's just termed differently because it's not a parenting plan. It's not a parenting plan that was mutually agreed into by the parties, but looking now into a deeper inquiry done by the family advocate, because they also have, for an example, like very informal interviews with the children, like a social worker, whilst in that play section, will have, like very informal interviews with the children, trying to understand where they lie, love mom, love dad, what's going on, who do you prefer staying with, and all that. So that's a whole inquiry that now as attorneys we can't do, but the family advocate's office can do, because they have resources, for an example, of social workers designated to actually do assist their office in that regard. So it's both ways, but it's something that can be done. It's the parenting plan, or if one cannot cooperate and doesn't want a parenting plan, or is avoiding the conversation around the parenting plan, it doesn't mean that mom cannot have a way. You have a way, you still consult with your attorney. The attorney will tell you that, okay, we'll have to do an inquiry through the family advocate's office, because dad needs to be part of the child's life. And even to mom must not feel defeated, and maybe also a very important distinction to make. The family advocate, when we go there in circumstances where the parents have not now signed a parenting agreement, we're going there for an inquiry, the family advocate will not make a ruling on maintenance, for an example. It's not their role. We still have to go through the maintenance court, unfortunately. It only deals with the needs of the child. Emotionally, psychologically, balancing the whole mom and dad presence in the child's life, but the financial part of it still needs to be done by the maintenance court. And the reason why that is like that, it's simply because the maintenance court will go deeper into the financials of both parties. They have the right to scrutinize bank statements. They have the right to ask, for an example, for salary slips. We can go through a Section 65, for an example, an inquiry to be done. You get an order, maintenance court, and if the party is still not paying, we garnish the parent's salary, that indeed once before it hits his bank account, the employer must know this portion must be paid through. So those powers would not be powers that the family advocate can invoke, but it's powers that are invoked through the court process. Henceforth, the two can still need to be separated. Maintenance court needs still to go through the maintenance court route, and the family advocate's part will still be separate, because it's two parallel things. They're not aligned. But yeah, I hope I've answered your question.
No, you definitely did.
Yeah.
So now, let's say we have a situation.
Yeah.
I am a mom, or there's a millennium. Let me not use it. There's a mom. The dad doesn't want anything to do with the child. They're not supporting. They're not doing anything, right? And they come to you. You go through the process. Let's just say the child's living expenses are 15,000, including school fees and everything. Once you guys have looked at everything, and then you look at the dad, and they have their financial commitments are like so high that there's no space for the dad to support the child. What do you do in that situation?
So that's what the maintenance officer is there for.
Okay.
Right? So I plead my case of the mom in the scenario that, look, these are the expenses of the child. But also maybe to backtrack, a very important point whilst you were raising that crossed my mind that I needed to highlight. This thing of, maybe let me try to find a better way to put it. The child expenses, right, must be very considerate of the child expenses indeed.
Oh,
Right.
yeah.
So in other words, mom can come to me and say that, okay, these are the child's expenses. It's 30,000 a month, and 30,000 is 30,000. I'm not willing to reconsider or like I have swimming, I have this, I have this, I have that. Like these are just the expenses, and dad needs to basically pay 15,000 of these expenses. The court does not work that way.
Okay.
We need to be reasonable. We consider reasonableness, and the court is going to consider reasonableness, and the maintenance officer is going to consider reasonableness. For an example, if you are having 6 activities that the child is doing, which probably amount to 10,000 of this 30, right? And dad is having a lot of expenses on his side, which he says, I'm unable to commit to 15, but I'm able to commit perhaps to say 10. So in other words, we're moving now from 30 to 20. Mom cannot insist on keeping the 30 if the 30 is really unreasonable. If the child is having extramural activities that would perhaps be the 6, we can look at saying, how about 4? Right? Because a very important factor that I've noticed is moms, unfortunately, like to perhaps have, I think it's because like motherly by instinct, right? And they like to really have the upper hand in the situation of financials, right? By not consulting dad.
Okay.
Dad needs to be consulted. And this is what we also include on that parenting plan. For an example, schooling. Dad must agree on which school
the child goes to.
Yes. Dad must be part of the conversation, because you're not going to then find a school that says per annual is 150,000 and come to dad and say, hey, look, found a school. Here's a school. These are the fees, 150. So we're probably looking at about 75,000 that dad must pop out, and you also pop out 75,000. Dad has every right to say, no, I did not agree to this. You didn't consult with me. We never looked into my affordability as dad. Will I afford these fees? So that's why it's very important to consult. It's very important to inform. And I do understand that in a scenario where dad is not actively participating in the child's life, you can make that determination as mom, right? To say, I'm going to take my child to a school that perhaps same scenario, that tuition is 150,000. But you can't then take dad to maintenance court thinking that the maintenance court is going to say dad must fork out 50% of that 75,000 a month. No, the maintenance officer is going to look at that decision. Who took that decision, right? Let's apply reasonableness. Okay, mom, you're in this position. Not to say that the maintenance officer is going to say, no, continue to pay the 150. No, but we'll look into dad's affordability, right? And if now, mom, you can't afford this 150,000 that you've committed to, what best can we do? Can we then look at moving the child to maybe 100K school that maybe dad can afford 50K and you can afford 50K? And in the interim, what do we look at? Because perhaps let's say it's June already. The child cannot just change, like schools like that. So are you going to be able to maintain this until, like December? And then next year we'll look into another school that dad can afford. And of course, it's understood that the reason why you took that decision at the time, you were in a good financial position. But it's very important to highlight this thing to say that just because you take a decision as mom with the dad not being involved, in that decision, and it's not by choice maybe for mom, it's because, well, it ended toxic, but now I'm here and I do need the help of dad. And I do also want dad to participate in the child's life, but financially I'm struggling. It's important to highlight and emphasize the fact that we need to reconsider then what are the financial commitments that you've taken, right? And these financial commitments that you've taken for the child, can they be cut off if dad cannot afford? And what is best for dad also? So it's not just an automatic thing that you're going to come with a figure and you'll say,
you get it.
I want 50% of this. No, it doesn't work like that. Because at the end of the day, unfortunately, yes, the dynamics were not favorable for you to sit down with dad, but you had to sit down with dad, or both parents had to sit down and discuss these financials. And it's unfortunate, but it's also fortunate, because flipping the coin, I mean, even if it's mom, if dad had committed to 200,000 financials, for an example, for tuition only for the child, and dad is now coming to you as mom to say, well, I need 100,000, would you be able to putting yourself in that scenario? And if you can't afford, you can't afford. And if you are saying, well, I can only afford 50, then you need to understand when he says I can only afford 50, for an example, for tuition. So it's about reasonableness, it's about fairness. And if dad has overcommitted in his financials before you take him to maintenance court, which was also part of your question, the maintenance officer will do the same scrutiny, will go through the expenses. Are the expenses reasonable? It doesn't necessarily mean that, okay, dad is just going to say, I can only afford 50,000. And the maintenance officer is going to take 50,000. No. If dad has expenses that are unaccounted for or unexplainable, or are expenses that you're just like, no, but then you can cut in this. You can, for an example, be buying luxurious cars and having an extravagant life and buying like expensive alcohol, for an example, over the child's needs, and you want to maintain the same standard into saying these are expenses over the child's needs, then the maintenance officer is not going to rule in that. Like the maintenance officer is going to say, no, but you can't be buying, for an example, alcohol for 30,000 a month, and you're saying you are not able to cut that expense to accommodate the child's needs. So it's all about scrutinizing. That's why it gets to be, to touch on a point that you raised earlier, that it can be tedious. It's tedious because of that. Maintenance officers are sitting with a lot on their plates, because it's not just about what the parties will be presenting to them. We are fighting also for our clients, and we'll be like, no, but maintenance officer, my client says that this father has an extra job, has a tender somewhere, so don't look only into
there's a business
just
this.
Because my client is telling me this information, and I need my client to get something fair, so they also have to go an extra mile to try and find this information. So that's why it gets to be tedious. So we need to apply a little bit of reasonableness when we look at maintenance officers, because they sit with a lot. It's a lot. Today I can say there's this account. We get there. I say, well, my client says there's another account at X bank, for an example, that he has not disclosed. He only disclosed Y bank that he's banking with. And the maintenance officer is just like, oh shucks, well, now I have to go to X bank, right? So I can't make a decision today. And there's a way in which he gets to X bank's access. Like there's a procedure to get there. He can't just go there, you know. So we need to apply reasonableness, because there are timelines that are set. He needs to wait for the bank, for X bank now to respond, you know, to what he's serving to them, to say he wants access in this bank account, especially if parties are hiding. You know, if you're hiding information, I mean, also for my client, I'll be digging, and I'll be making sure that, okay, whatever that this guy is saying, he must be saying something that's correct. If you're saying you're banking with A and B, there must not be a C there that I see. If you're saying that you're employed at a ABC company, I must not find, when I do my own digging as an attorney, you having another company called a NZY. Why is there NZY? So I'm going to come with that information to the maintenance officer and say he's lying. So it prolongs. It really does prolong, but it's not to say that it's not worth it at the end. You do get some fulfillment at the end to say, okay, well, we tried all avenues, you know, and this is indeed what dad has. And now let's get to the bottom of it. This is what dad can affordably pay for the said child or the children. Yeah.
What happens if a dad says, I don't want to be part of my child's life, I want nothing to do? And maybe the lady met the guy, they had a 3-day situation. Lady falls pregnant and the guy's like, keep your child. Or maybe the guy was like, have an abortion. And the woman was like, no, I'm keeping the child. And then the guy's like, well, then don't involve me.
This is a very funny, serious question. It's funny because, unfortunately, there's no answer in law that forces mom to say, you're going to force a child to dad. It's unfortunate. And that's just the long and short of it. It's unfortunate. You can't force dad by law to be part of that child's life, especially if dad had expressed that he doesn't want the child. Because we do have scenarios where, let's say it was that one night or two night situation that went on, and mom will say, okay, I'm pregnant, right? And dad will express that, please get rid of the child. I don't want the child. And indeed, mom has the right to say, no, but then I want the child, right? I'm going to keep this child, because no one can tell mom to get rid of the child. It's also like a right issue. It's my right. You can't tell me to abort a child, right? But same way as it is mom's right, dad also has the right to say, I don't want the child. You can't force dad to be in that child's life. Yes, responsibility wise, financially and supporting the child, there is a way, like which would be maintenance. Like you have to maintain the child. But emotionally, psychologically, and otherwise, having dad actively partake in that child's life, no, there's no law that can that forces, at least for now. It's yet to be developed, because I mean, law is jurisprudence. We develop the law as we go. It's an area that still needs to be explored in South Africa. But I think it's just about the balance of the rights, especially in a scenario where dad had expressed that I do not want the child. You can't force dad to be emotionally, psychologically present in that child's life. You can't. Financially, sure, through maintenance, it's your child, DNA proves it. We can go through that route. He will be able to support the child financially for that. But beyond financial,
you can't.
As for now in South Africa, there's no law that says we can enforce the father to be part of that child's life.
Yeah. Okay.
Yeah.
So a happy scenario. Mom lives in South Africa with the child. Dad lives in the UK, and you want to do a co-parenting plan. You guys both want it. And I've got you as my attorney to help. Does Dad need to get his attorney in the UK, or we can just go with the South African attorney and do everything by the South African system, if I can put it that way?
Child born in South Africa, let's say child born in South Africa, I
Yes.
assume in the scenario,
Yes.
Child has a South African birth
Birth
certificate.
certificate.
Mom, dad are South African, or one of them is probably,
But one of them is from the UK.
okay, that's still fine.
Dad is UK.
Okay,
Yeah.
that's fine. That's
But
still
They
fine.
both on the birth certificate, everything.
Child South African.
Yes, child.
No,
South
that's
African.
fine. We go through the South African attorney. So mom, as mom is my client, we can go through
Okay.
me, right,
Yes.
as the attorney drafting that parenting plan, and we get to endorse it. We get a court order. It gets to be a valid parenting plan through a court order. However, very important, I will have to have consultations with dad, right, to confirm that
This
you
is
guys are
fine.
agreeing, this is what you're agreeing on. Dad also can have his attorney in the UK to peruse and check if
everything
everything is happy, so that it doesn't seem like I favored my client in the
Yes.
agreement.
Yeah.
But in terms of it being an official document, it would have to be in South Africa.
Okay.
No other way around it.
Okay.
Yeah.
All right. Okay.
Yeah.
Sure. So, I spoke to you
Yeah.
the other day, and you're like, Animameli, Animameli. You guys don't listen. And I came to you, and I was so distressed because I watched something,
Yeah.
and obviously
Oh, I
touch
know
wood,
this.
it doesn't happen. If I pass on, automatically I'm like, my sisters, they will sort my kids out. Ne? A scenario now, dad is not present financially, physically, emotionally, everything. Mom didn't go maintenance. Mom didn't go whatever. They were like, you know what? This is my child. I'm going to take care of my child. I've got the means and I've got the support, right?
Yeah.
When I pass on, my sisters will take care of my kids. Ne?
Okay.
And then an unfortunate situation, the mother does pass on. And the dad is like, these are my kids. This is my child. The child is probably, say, underage, obviously, to be like, no, this is where I want to go, whatever. How does that scenario work? We've got 15 minutes left. And I want us to end there because I was very disturbed when I watched it. Because for me, it's like, hey, let's try and prevent what hasn't happened, or let's educate ourselves to say, these are the things that can happen.
Yeah.
And how do we then maneuver around that?
Yeah.
Because you want something to be at the best interest of your child.
Yeah.
And you can find that the sister has been very involved in co-parenting, if I can put it that way. They know the child in and out, everything. And then here comes the estrangement that says, thank you, I want my kids.
I'll never emphasize enough the importance of information and of anyone who has a child to go to an attorney. Structure your things.
Yeah.
Because in this scenario, indeed, dad has every right to take the child. It's his child. South African law deems mom and dad being the primary caregivers of the child. Mom, dad, primary caregiver. Not aunt, uncle, grandmother, grandfather. No, those are not primary caregivers of the child. Primary caregivers are mom, dad, right? So when mom passes away, automatically, who's the primary caregiver they left? Dad. It's not aunt, uncle, grandmother, or grandfather, whether paternal or maternal, right? It's the duty of dad, because dad is the remaining primary caregiver of the child, right? So dad has every right to say, well, I'm dead, it's my child. But now, an important factor that needs to be considered, that we consider, is, okay, the child does not really, know dad. Dad does not even know the likes and the dislikes of the child, right? And did mom pass away with a will? Very important. That's what we ask. Okay, we say, okay, at least there is a will here. Let's say there's a will. There's a will. Okay, what did mom say in the will? Okay, mom said, my child must stay with my sister, right? And here's dad now saying, I want this child, right? Then in that scenario, we are fortunate because at least there's a will.
Yeah.
At least there's a will. There's a will that gave a direction, and a will remains a valid, document that is very important. If there's one thing that I need to emphasize for everyone who has a child, please do your wills, guys, because it remains being the most valuable document when one passes away that governs such a situation. If the will specifically said that my sister must be the one who will take care of my child or my children should I pass, then we go through the court route, right? Let's say dad goes through the court route to fight that I'm the primary caregiver of this child, but now certain important circumstances will have to arise, will have to be argued before the court to say this child is not used to this man, this child has never day one been in this child's life, and this child is used to the aunt. This child has navigated life with the aunt. This child's best caregiver in this instance is what? Is the aunt. The will says the aunt must take care of the child, right? In that scenario, the court is likely to say, as much as but you are the primary caregiver, you dad, you can get access to the child.
Yeah.
You can get introduced to the child, like gradually. But we can't invalidate or override what the will said, right? We can't say that, no, just because you are the primary caregiver, right, by virtue of you being the dad, yet you have never been in this child's life at all, that you are just going to be given this child. Because there's also a process of the court satisfying itself that you'll be a good father to this child. So the process will have to then first start and unfold before the child is handed over to dad. So at least there's a protection there, because there's also that will that is a valid document that is here. These are the last wishes. And in that instance, the court will say that the child will stay with the aunt until otherwise the dad has passed certain stages, right, for the court to be satisfied that dad can then take over to stay with the child. First of all, there's so many stages that one has to go through in that instance. For an example, a social worker will have to be appointed. The social worker will have to go do a home check.
Okay.
To see, who's dad staying with? How is this environment? Will this be an environment conducive for the child? I mean, will this environment be best for the child versus, like where the child is staying with aunts, right? So the court is not reckless to just go for, the primary caregiver, especially in this instance where there is a will, it's a valid will. There is an aunt who has been actively participating in this child's life. Dad has been nowhere in this child's life. It doesn't override. However, very important to note, had there been no will in this scenario, the dynamics change, because there is no governing document that says what must happen post this child. And the fact that dad remains in the scenario being the primary caregiver that's available and that's still alive. The court, yes, will do the checks. They will not automatically just give over the child to dad. They will do the checks that are supposed to be done. And upon them receiving the report from the social worker, from the family advocate's office saying that indeed dad is okay to stay with the child, dad will stay with the child. But likelihood, even in the interim, they might likely go for dad because dad is a primary caregiver of the child. However, the checks will still need to be done, though. The child will be staying with the nominated family member by, like the maternal family. However, the child, it's automatic that the child would go versus where we have a will. And the dynamics are different because the will says this. Yes, there is a primary caregiver alive. However, we can't just automatically strip off the fact that there is a will that's valid. Dad can have access to the child, develop his relationship with the child, and likelihood is that the child is going to stay with the aunt, but dad is having access. Right now we're developing that whole thing of parenting plan, but it's just that mom is no longer alive, but dad still has, like visitation rights. Gradually, we're introducing the child to dad. It's not just that automatic. So the important thing that one must take out of this last question, is that a will is very important because there are real scenarios out there that can really be, like sad that, the child ended up in a family that doesn't know nothing about the child. And it's unfortunate because there was no will in that scenario. And yes, the checks were done, by the court system through the family advocate's office and the social workers assisting the family advocate's office. But emotionally, the child grows up in an environment where preferably they wouldn't have preferred to be in that scenario. They would have preferred maybe to stay with mom's family. But because there was this one thing that was not there, at least to assist the court as well in making the decision, then the child ends up being in the other side of the family. And this is, vice versa. Whether mom passes away first or dad passes away first, parents must just do wills.
Yeah.
Parents must just do wills and make life easy for even the remaining, family members. So it's important for parents to get information and for parents to actually go out there and consult. Go to attorneys, guys. Attorneys are there for that, to consult, to guide you, to make things a little bit easy should you pass away, and to make things easy also for your children, because there's nothing much to fight for when there's a will. There's nothing much to really argue, to fight, even when it comes to financials, even when it comes to looking into tuition, for an example, university tuition. Should you pass away, what must happen? Because mom can have, now I'm tapping into another.
That's fine.
But anyway, I wanted to say that mom can pass away, child still in primary. Mom had all the policies in the world, all the policies, but mom passes away without a will.
Sure.
Mom has nominated the sister or the uncle as the one to, help out with the child, have access to those finances. As much as we trust and we love our family members, but you don't know once you pass away, will they remain being the same?
Yes.
Will they not be tempted to, use that money for something else? And come first year varsity,
Sure. There's no money.
there's no money. What happened to the money? What happened to all the millions that mom had invested and which actually were paid out? What happened to that? That's why it's very important to have a will. Have the conversation with your attorney. What can I do? We will advise you. Let's do a trust. Let's do a trust, for an example. Let's do a trust. Do you want these monies to, some of your policies, how did you structure them? Have you structured them that at least they must pay off when the child is 25? Because some people don't even know that there's actually a way to do that through your policies, to say, no, should I pass away, do not pay out. This portion must not be paid up until the child reaches 18, for an example, and it must be paid over to the child's account. You make those things structure the way in which, at least life can work around post your death as a parent. And that's why it's very important for you to consult, because some of these things you will not know unless you go and consult with your attorney so that they can structure such things. And it's a real thing. Death will happen at some point, and no one knows when death will occur. But at least the least you can do is to say, I structured it well, or as best as I can could. Think. And indeed, as I could, so that whatever happens, should I be no more and my child is not yet 18 or not yet 21, I know that they're safeguarded into financial care. So long short of it, please, people must consult.
Take home message, people must consult. Yeah. People must have a will. And people must read and be informed.
Indeed.
Because we don't want a situation where something unfavorable happens, and then, because kids, my daughter is 3, for example. Like people have like 8-year-olds where they're not above 18 and they can sort of be able to make certain decisions. So I think we avoid certain things because I don't want to plan for death. Oh my gosh, what's going to happen? And it's more like of a mental or emotional thing, but we need to be practical and we need to just make sure that we've got everything in order.
Yeah, and it's not to say, one is dying. Yeah. It's just to say, in the event of this happening, is there a plan? Is there a contingency?
Yes.
There must just be a contingency plan. There must just be a contingency plan.
Yeah. But thank you, Pilar. The time, it's never enough.
Time will never be enough.
Time will never be enough. If somebody wants to contact you and they're like, actually, I am dealing with this. Yeah. Where does one go?
Okay. Firstly, you can contact me on my number. It's 073 600 4767.
Yeah, we'll put the details as well.
Online. And also you can send me an email, right? It's philasande@mkse.co.za. We'll also provide those details. One can also go and consult with me at our offices through, of cause an appointment, you can see me. If you want, I'm also on Instagram. You can inbox me and I'll give you the directions. It's MKS Attorneys.
Okay.
I'll also provide you with those details so that you can put them in on the screen.
Put all the details. Thank you so much. Thank you everyone for watching. Please, if you need to contact Pila or any attorney, if you're not in Johannesburg, please do, because this is more serious than we actually think. It is. So if you believe that there's somebody else that can benefit from this, please do share, please comment, please like, please subscribe, and thank you so much for watching.
Thank you so much.
Bye.